The Fifth Circuit decision, which found that suppressors are not arms and therefore does not trigger 2A protections, is once again up for review. And now the DOJ is changing their position on this suppressor issue. So let's break down what is happening. Now, really quick before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That helps the channel to grow. And also just double check to make sure you have not been unsubscribed by YouTube, because YouTube loves to do that. And then also just drop a positive comment down below, because that helps to tell the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was ruled on by the Fifth Circuit Court of Appeals. And now this case is also seeking Fifth Circuit en banc panel review of that horrible decision. This case deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be discussing is called U.S. versus Peterson. This case involves an individual who had a gun store at his home that was raided by the ATF. During that ATF raid, they found a single solvent trap that was not registered or serialized under the NFA. And because of that one item, the individual here, Mr. Peterson, was charged with violating the NFA and was charged criminally. Mr. Peterson challenged the conviction based on a theory that the NFA and its suppressor restrictions do violate the Second Amendment. On review, a Fifth Circuit 3-judge panel found that suppressors are not arms and they do not trigger 2A protections. However, the case is now seeking Fifth Circuit en banc panel review, and the DOJ here, the federal government, is having to respond. But the DOJ through Pam Bondi have signaled that they have potentially considered major federal shifts when it comes to the issue of suppressors. Last we talked about this case, we found out that some Biden administration holdovers in the DOJ had filed a brief in this case. They continued to argue to the Fifth Circuit that the Fifth Circuit en banc panel should uphold that lower court decision and still find that suppressors are not arms and not protected by the Second Amendment. But now, because of all the noise that we made about this case, the DOJ and AG Pam Bondi have shifted policy. The DOJ has asked for another delay in this case so they can reconsider what they want to do in this challenge. And we know through some social media posts from the chief of staff for Bondi that they are focusing on changing course on the issue of suppressors, and they mentioned the suppressor case expressly. And now, even more importantly, we know that the 2A task force that was established by Pam Bondi is stepping in this case. Now, in this case, back in 2022, both federal and state law enforcement officers executed warrants at Mr. Peterson's home in Louisiana. A federal task force, including ATF agents and then about 50 other law enforcement officers, executed warrants at his home, searched his home and his local gun store that he had within his home, and they seized a bunch of his property. The search warrant was based on issues with Mr. Peterson operating the gun store out of his home. Specifically, the ATF alleged that there were straw purchases, improper record keeping on 4473 forms, a failure to complete and forward multiple firearms transaction forms to the ATF, and then there was also some issues related to some products that were sold out of his store that were then later showing up at crime scenes. Now, during this entire search and the entire warrant being served, they found a single solvent trap within his bedroom in his bedroom safe, and it's that one item that got him in trouble. He was charged with having an illegal suppressor or silencer which was not registered or marked or serialized according to the NFA, but in response to that single charge, Mr. Peterson filed a motion to dismiss based on the Second Amendment. He tried to use the new Bruin analysis to override this charge against him. On review, the court denied that motion to dismiss, and then he appealed up to the Fifth Circuit for a reversal. On review, a 3-judge panel in the Fifth Circuit sided with the ATF and the Biden administration, finding that Mr. Peterson's motions were properly rejected because the Second Amendment is not implicated. In their ruling, the Fifth Circuit stated that whether suppressors constitute arms is an issue of first impression in our circuit. Insofar as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looked at whether or not suppressors are weapons of offense or armors of defense, or are they used to cast at or strike at another. So they're using kind of the broad term that is used often by the Supreme Court to determine what is an arm. The Fifth Circuit incorrectly found that they are not arms. They stated that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. But that is wrong, the Fifth Circuit stated. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown, which of course is not how a firearm works, it cannot do any casting or striking. The Fifth Circuit went on to find that a suppressor is not a necessary accoutrement of a firearm and that it is not required to make a firearm actually useful or functional. Now, that inherently is a concerning decision, so Mr. Peterson has now, through his counsel, filed for a rehearing en banc in the Fifth Circuit. The DOJ responded to that petition for a rehearing en banc by arguing that the prior decision by the three-judge panel in the Fifth Circuit was correct that suppressors are not arms and two-way protections are not triggered in this case. In my prior videos, I told you that all of this was likely done through some Biden administration holdovers within the AG's office, and it appears that is exactly what happened. That has almost been confirmed not only by the AG's office trying to now delay this case so they can course correct and change some of those arguments that have already been made, but also we now have confirmation that multiple individuals have been fired within the ATF, within the DOJ. There's kind of been a cleaning of house and getting rid of a lot of those Biden administration holdovers. Now, recently, the DOJ's office and the AG's office here have filed a notice to the Fifth Circuit en banc panel, and they're asking for a further delay in this case so they can course correct. This new notice from the federal government states that the United States of America moves this court to delay its ruling on defendant appellant George Peterson's petition for a rehearing en banc for another 30 days to allow the government an opportunity to further consider its position. On February 6, 2025, this court affirmed Peterson's conviction for possessing an unregistered suppressor in violation of federal laws and held that silencers are not arms protected by the Second Amendment. After affirmance, Peterson filed a petition for rehearing en banc, which was supported by amici curiae briefing. On March 18, 2025, the government filed an opposition to Peterson's petition for a rehearing en banc, arguing that the panel's holding was correct. The government later requested that the court delay its ruling on Peterson's petition for 30 days to allow it an opportunity to further consider its position due to the Executive Order 14206, which is the Protecting Second Amendment Rights, in which the President directed the Attorney General to examine all executive actions and present a proposed plan to protect the Second Amendment rights of all Americans. In implementing that order, the Department of Justice is reevaluating its litigation positions regarding suppressors. This court granted the government's motion on March 24, 2025. After the court granted the motion, the Attorney General formed a Second Amendment task force related to the executive order. The government continues to actively review this case, but requires additional time to evaluate its position and present it to this court. Accordingly, the government requests that the court delay ruling on Peterson's petition for a rehearing en banc for another 30 days. At that time, the government will inform this court of the status of its review and, if warranted, move for leave to file an amended response. Now, why is this important? Well, this shows that there has been kind of a complete shift when it comes to suppressors and this case. The Biden administration continued to argue that suppressors are not protected by the Second Amendment. But now the 2A task force, which was formed by Pam Bondi to execute that executive order that was put in place by Trump, it seems like they are now going to step in and decide procedurally how they want to handle this case, but also how they will advocate for 2A protections when it comes to suppressors. We have already seen the 2A task force kind of take action in other cases like the Range versus Garland case, and they decided to drop the federal government's request for Supreme Court review in that case. The administration has also taken action against localities that are delaying CCW permits, like the County of Los Angeles. And they also decided to do things like revoking the Biden administration's zero tolerance rule. And one of the other things they did is reopen the federal restoration of rights process that has been closed since, I believe, 1995 or 1992. Now, all of this is a good sign. And this notice saying that 2A task force will be reviewing this suppressor case and deciding how to proceed forward is also another great step forward. So now this issue of whether or not suppressors are protected under the Second Amendment and whether the NFA violates the Second Amendment will likely be put on hold for another 30 days so the 2A task force can decide how they want to handle this case. I suspect it will ultimately play out well for Mr. Peterson and the 2A cause at large, changing policies in regards to suppressors. We have that tweet from the chief of staff saying that they are focused on changing perspectives about suppressors and reevaluating all these suppressor cases. And this is kind of the big one that's getting a lot of attention. And it appears now the 2A task force is stepping in this case. So again, a very important case. And now we're going to see what the 2A task force decides to do on suppressors and how they decide to proceed forward in this challenge. So as we get more information, as this develops, I will let you guys know, but generally really good signs. So if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.